just the meaning, everyday meaning of we the people. And so here we meet as the legislative branch in the capacity of a House Standing Judiciary Committee, and I'm Representative Christensen, fortunate to be the chair, and Representative Merrill Nelson, who's with us today, also is our vice chair, and he'll be conducting the meeting, so I'll turn the microphone over to Representative Nelson.
Like that. Very good. Thank you, Representative Christensen. Chairman Christensen. All right, we have an agenda. It looks like it's the second revised agenda to make sure we're all looking at the same thing. A couple of modifications were made. And first on our agenda is Representative Cutler, House Bill 73, Nepotism Amendments. Representative, if you'd like to take the stand.
That's a carryover from last meeting.
Oh, is it? Okay. Apparently this is a carryover from last meeting, is that right, Representative? Why don't you go ahead, we'll turn the floor to you.
Before he does this, I have a motion to approve the minutes.
I'm informed we need to approve the minutes first. Can I have a motion on that? We don't have any?
We don't have those yet.
No minutes.
We'll come back to that.
Disregard that.
We've got the hours, just not the minutes. So there we go.
Let's see.
I believe so. 2, 3.
We do have a quorum.
7 of us.
Very well. We'll go ahead.
You ready?
Representative Cutler, the floor is yours.
Thank you very much. As was mentioned, we met last time in this committee and looked at this nepotism bill. I'm waiting for the slides to come up. I think it came unplugged. Okay. And you have it before you, the new bill. Trying to bring up a slide here. It's not coming up now. Just was up. So I will go on. So the initial proposal was to add grandparents and grandchildren to this. And see if I can get this to duplicate. Okay, I'm not getting the slides to come up, so I'll move on. And then as we got looking at it, as you'll see on the second page under relative means, was a father, mother, husband, wife, son, daughter, sister, brother, etc., etc. And then we got suggestions that there we go, now I got the presentation. Okay. That we add some additional grandniece and grandnephew. Got looking at a number of other nepotism bills throughout the country, and they use a term which I was not familiar with, which is consanguinity. I can't say it. Consanguinity?
Consanguinity.
Okay, consanguinity. And so as you'll notice in number D, relative now means a person who in relation to a public officer, incidentally this has to do to define who a relative is. Person who in relation to a public officer or an appointee, as the case may be, is or was a spouse, is or was living as if a spouse, is related by blood within 3 degrees of consanguinity or by marriage, has or had one or more children in common with a public officer or appointee, is the biological parent of the public officer's or appointee's unborn child, or is in an intimate relationship with the public officer or appointee. We're trying again to address the need we have here to not employ or have individuals working for another person that are related, and the challenge is defining related. So that's the first thing we've done, is we now have these 6 various definitions of what related means, or what a relative is. Also, you will notice that we have scratched out under 2 item number 6, and I think this caused some confusion, at least for me, when I was here the last time. Again, I wish I could get this up. Oh well. And if you'll notice, it says no public, in number 2A, it says no public officer may employ, appoint, or vote for, or recommend the appointment of a relative, etc., except as follows. And you'll notice number 6 is repeated also in the following section. When the public officer supervises and comes down.
Representative Cutler, let's clarify what you're working from.
Yeah,
Rep-
this is,
Representative
I guess the
King,
first
are
thing.
you,
Yeah,
did I get you there?
okay, I apologize. The first thing I need to mention is this is first substitute, so I think we really
Right.
need to have a motion to approve first substitute. So I apologize.
And would you
Yes.
like a hard copy?
Point of order.
I've got a hard copy. Yes.
So the point of order is that you're looking, Representative, at, you're reading from something that we don't have in front of us. So I would make a motion to, that we adopt, is it first substitute or is it amendment?
Substitute, yes.
First substitute HB 73 to be before us.
The motion is to delete in title and body House Bill 73 and substitute there with first substitute House Bill 73. Any discussion to that motion, Representative Cutler?
Again, we've just changed, based upon our last discussion of what we're doing. And so we have made some changes to that, as I mentioned. I'll go back and go through it now that we have the right copy in front of us.
Let's proceed with the motion first. Any discussion from the committee on that? Representative Cox.
Thank you, Mr. Chair, or Vice Chair. By deleting number 6, when we discussed it before, I thought we had the provision that if the person being appointed was actually the best person for the job and somebody else, maybe a chief administrative officer or whatever, approved it, so that this was done on more than one level and not just somebody appointing their nephew, that was still an option. And I guess the question is are we getting rid of that possibility?
Representative, rather than debate the substance of the bill, let's
No,
first...
I just was wondering if the substitute changed that, but I'm looking at the
Okay.
comparison and it was crossed out before, so I withdraw my question.
All right. Any other discussion from the committee on the motion to substitute?
I have a question.
Representative Chair Christensen, go ahead.
I guess to the bill sponsor, I'm a little surprised, and I just want to make sure I understand. I know that we normally just let a person introduce the substitute, so we're not trying to go to the merits per se, but we do try to understand the distinction between the before and after the underlying as opposed to the substitute. I appreciated last time, I thought at the very end of your presentation, one of the things that was extremely helpful was that you talked about the fact that it was really focusing on a supervisory position. You could have a very large department and let's say they had 1,000 employees, and to say that there was a blanket prohibition on a relative somewhere in those many, many branches, but it was much more focused on concentration of nepotism, not just banning a family. So my question is this, is I'm looking at these new definitions of relatives, and I'm a little bit surprised by that, because I don't, but is that what you're wanting to propose? You want us to consider in your substitute a different definition of relative, because the current law has those terms there, but you'd be striking them now and changing them for different descriptions, including an intimate association and some other things that are different from current laws. Is that what you're?
That is what I'm proposing.
Okay.
All right, seeing no further discussion, let's have a vote on the motion to substitute. All in favor, say aye.
Aye.
Any opposed?
No.
We have 2 negative votes, Representatives Christensen and Cox, on the motion to substitute. The motion passes. The bill is substituted. And Representative Cutler, you're free to proceed now on your discussion of the first substitute,
We will
House
start-
Bill 73.
I'll start over. Thank you. So the initial proposal was to simply add a grandparent or grandchild and stepchildren to the existing definition. Then, after we submitted that, we got from the HR department, said, well, perhaps because we've added stepchildren, that we should add grand stepchildren to that. And then we had another one come in, well, perhaps we ought to have close relationships because oftentimes they're very close relationships. And how do we define those? And they just became too many permutations of this and too many ways of defining that. So again, we've changed the consanguinity to the third degree, and I'll just explain what that is. Hopefully you see the slides now. And it will include non-married as well, but living together. So if you look at item D, going back to that, does everyone now have the right one in front of us, I hope? First of all, sanguinity is defined as this, and you'll see this is how you define the first and second and third. I didn't know that, in case you're interested. This is where you can determine who is of a first, second, and third level of the sanguinity. So the definition now of a relative is or was a spouse, is or was living as if a spouse, is related by blood within this 3 degrees of consanguinity or by marriage, and then has had one or more children in common with the public officer or appointee, is the biological parent of the public officer's or appointee's unborn child, or is in an intimate relationship with the public officer or appointee. So that again defines relative. That is the primary change here. The next change you'll notice under 2 is item number 6, which if we read through it, is not consistent. It seemed to be a duplication and didn't really fit after we read it. Where it says no public officer may employ, appoint, or vote for, or recommend, etc., except as follows. But then it talked about the chief administrative officer determines that the public officer is the only person available or best qualified to perform the supervisory functions. Well, item number 2A is not talking about the supervisory functions. The supervisory functions are discussed in item B, and number 7 addresses that one. So as I met with the legal staff, we looked at that and says, oh, that really doesn't fit, because the first one's defining who is hired, item B is defining who supervises that individual. So those are the changes to that particular section. And we have discussed this, by the way, and I think I mentioned this last time with HR, and they're saying there only case may be in some of our outlying areas, challenges with hiring those, but again, we go back to saying if they're the best qualified to hire or the best person to be supervised, then they can be supervised by that individual if the chief operating officer, chief administrative officer determines that. So I will now stop and see if there's any questions.
Thank you, Representative. In the next phase of our process, we'll go to the committee for clarifying questions about the proposed bill. And we have a couple of lights here. Representative Oda, have I got you?
Yes. Thank you, Mr. Vice Chair. In line 31, it obviously defines what a public officer means, a person who holds a position that is compensated by public funds. But I don't see anywhere here, and maybe maybe it's stated somewhere else in that section of the code, but it doesn't say what type of employer. Is this strictly for government employment?
As far as I know, this is just government employment.
I want to be absolutely
State
sure
employees.
because I don't want some kind of a trap. If I were, because I have some compensation from the state for being a legislator, and I hire, say, my son or my wife as a secretary for a private business. I don't want it to be a private, affecting that. Nor would I want it to affect the situation if I hired my son to help me with some work, research or something on some legislation or something. Would that be affected by it?
if I read this correctly, if they're being hired by an individual, in other words, if you hire them as a state employee, then to the best of my understanding of this bill, then they might be.
But I don't, well, no, they wouldn't be employees of the state,
Okay.
but I don't see anywhere here where that really delineates that or separates that out. If I were to hire my son and pay for it out of my own funds, it doesn't state that that's excluded.
I think if you look under 1A, if I'm understanding, Representative Hall, your question, the appointee means an employee whose salary, wages, pay, or compensation is paid from
So
public
would that
funds.
be direct payment
Yes.
of taxpayer funds, or could that be construed to be indirectly routed through me? So if I get paid and I use those funds to,
That's a good question.
Hey.
I wouldn't, I'm not the legalese on that, I wouldn't know. But as far as I can tell to this, they would have to be paid from public funds. Now, if they're routed through you, that's a good question.
it just seems like it could create a little bit of a possible trap.
Yeah, which exists in current law
I
as it
know,
exists.
but the thing is, it could be it could be a trap now, and it could be a trap in the future with this. And if that's what it is now, I'd like to see this corrected.
Okay?
Thank you, Representative.
Can we find out from staff if that's the case, or what's your opinion on it?
Greg, do you have a comment?
Okay. I would have to look into that. I'd have to do some research on that to determine, how to what extent this extends. From the reading of the statute, it's stating direct payment. I think when you read that statute, the plain reading of that, but through indirect means, that's a question that we would have to research.
All right, the next light is Representative Hall.
This goes a little bit to the difference between the original and the first substitute, but I see that lines 55 and 56 are stricken. Did we really mean to strike that if this chief administrative officer decides that this is the only person or best qualified person, we're not going to be allowed to appoint that person?
No, if you look at item 2A5, the appointee is the only person available, qualified, or eligible for the position.
2A5, what line?
So that's line 53, sorry. So that one addresses that. If it is the only person available, qualified, or eligible for the hiring. So 2A refers to hiring, or 2B refers to supervising.
We're not in B. Stricken language is in A.
So it's your position that since line 53 is there, we don't need lines 54, 55, and 56?
Because we have it on line 70 and 71, address the supervising. The public officer is the only person available or best qualified to perform supervisory functions. Since 2B talks about who may supervise that person once hired, 2A talks about who can recommend them to be hired.
I see. Okay, thank you.
We went the rounds on this. We looked at this and says this says it was not right in the initial statute.
Thank you, Representative. Next light, it looks like, is Representative Green.
Thank you, Mr. Vice Chair. Following up on the question by Representative Cox, I don't know that I'm still satisfied with that. I do appreciate the explanation that answers some of the questions, but do we really want to prohibit an individual from voting for or voting for the hiring or appointment, or recommending the hiring or appointment of the best qualified candidate?
No, absolutely not. And I think line
you're-
53 addresses that.
It says if it's the only one available.
Okay.
But if there are two available, one is marginally qualified, the other one is the best qualified, but happens to be a relative, I think we've eliminated that. We've eliminated that scenario if we cross out 55 and 56.
And I can see that, and I would be willing to accept an amendment to that perhaps might add between the only person or best qualified in line 53.
Well, is there a problem with just putting 55 or leaving 55 and 56 in there?
I just looked at it, I was getting confused because 55 refers to the best qualified to perform supervisory function. Well, that doesn't refer to whether or not he's going to recommend him or not.
Right.
But I would be fine with saying only person or best qualified person in 53, because I think 54, we could leave it there. When I read it, I kept getting confused.
Yeah. That would be my preference, but I can't make a motion now. I'll either come back or hopefully somebody else will address that. Thank you.
Thank you. Representative Cox.
Thank you, Mr. Chair. And looking at the chart that you had on the screen and other ones, first cousin on line 34 existed, and on the new formula, it's not there. First cousin is a number 4 on your chart, so we are fixing it so that someone would be able to hire their or recommend their first cousin under the scenario that they wouldn't before. And I appreciate that you set the number 3, because if you go too high, I would run into, I live in Utah, and I'd be related to too many. There's lots of Coxes that are around, and some of them I'm related to, some of them I'm not, and some of the people I'm related to are not Coxes. So you start getting too high of a number, and I'm going to have a hard time finding somebody that I'm not related to. But I just wanted to point out that we have dropped first cousin.
Good point.
Thanks.
Thanks, Representative. I see no more lights or requests from the committee. We'll move to the next phase of the review. Do we have any comment from the public on the bill? I see none. So we'll come back to the committee for action. And Representative Green.
Thank you, Mr. Vice Chair. I have a motion to amend. I would move that we leave in, I don't know how we undo the deletion of lines 54 through 56 and leave that original portion of the statute unaltered. We haven't made changes in any of these others.
So the motion, as I are you ready, Representative?
No,
You've stated your motion.
That's my motion.
The motion then is to replace lines 54, 55, and 56 and not delete them. We have a whispered point of order here whether we exceed the number of words permissible for a verbal oral amendment. Can we have we're okay? All right. We have in committee, we're within the 25-word parameter. So the motion is well taken. And is there any discussion on the motion? Seeing none, Representative Cutler, do you have a response on the motion?
That'll be fine. Don't have a problem with that. I think it's a little clearer, but we were very confused, went back and forth as well, whether we need to leave it or take it out. But if we're more comfortable with it, that wasn't the main portion of the bill, so that's not a problem for me.
Representative Green, back to you for summation.
I think I made the point earlier, so I'll waive.
All right.
When you restate the motion, be sure to catch that or right there. You need to delete that or on 52. So delete the or on 52, and then reinstate reinstate the semicolon, the or through the period on 56. There you go.
We need to adjust the punctuation. Maybe we can leave that to the staff, but I'll restate what we have then in the motion. The motion is to reinstate the language on lines 54, 55, and 56 that shows a deletion at this point. The effect of reinstating that language will be to delete the or at the end of line 52, reinstate the semicolon at the end of line 53, restore the or on line 54, and restore the lines 55 and 56 with a period at the end of line 56. All in favor of that motion, say aye.
Aye.
Any opposed? The motion carries, and the substitute bill is amended. Sorry. Unanimously. Now back to the bill. We're going to Representative Cox.
Thank you, Mr. Chair. Motion to amend?
Another motion to amend. Go ahead.
Line 56, that's back in, the word supervisory. Change it to the.
The motion is on to amend is on line 56 to delete the word, to replace the word supervisory with the word the. Is that correct?
That is correct.
Would you like to speak to that motion?
I think this was one of the reasons the two lines were deleted initially, is the chief administrative officer determines that the public officer is the only person available or the best qualified to perform supervisory functions for the appointee. That evaluation is you're targeting the supervisor, and we're trying to decide whether or not we want to have this relative appointed, and I believe that word is what's causing the concern, and so I think that's the word that we need to look at. We obviously need the lines back in.
Anything further, Representative Cox?
I may be open to a substitute motion if somebody has a better idea, but I believe the lines need to be in there, but I think they still need to be clarified.
If there's nothing further, let's go to the sponsor of the bill. Representative Cutler, do you have any comments on the proposed amendment?
Well, again, that line still is confusing because of the context that it's sitting in, and that therefore we're seeing that now. That's why I struck it initially. But again, that's only referring to the administrator offer being the best available to perform the supervisory functions. It's not referring to whether or not they hired the person or whether or not it's the best person qualified. So it is confusing. It repeats itself. But if the committee wants to leave it in repetitive, that's fine. It'll repeat itself. So I don't know that his modification will fix it.
All right. Further discussion of the motion to amend. Representative King?
I'd reserve the right to make a substitute motion.
So noted.
I'll take a crack at this. I don't know that I'm fixing this, Representative Cox, but let me tell you what I'm thinking here. How about if we take lines 55 and 6 and delete supervisory, substitute the, delete the words only person available or. So it would read, the chief administrative officer determines that the public officer is the best qualified, you'd probably want to add person in there, to perform the functions for the appointee. That seems to me to meld the line before it. Representative Green's looking at me like, now I'm really confused. I'm trying to reconcile these two lines that make, in a way that makes sense. And Representative Cutler, you can tell me if I'm up in the night. If that works, great. We can make a substitute motion, and I'll make that motion. But if not, you guys can wordsmith it later if you want. I don't care. I don't want to take too much time messing around with this. But that seems to me to accomplish what you're trying to do, Representative Cox, as well as accomplish what Representative Cutler's trying to do. But I can see Representative Green is pregnant with thought.
Thank you, Representative. Back to Representative Green.
This is to the substitute motion.
Very good.
I think what the confusion that Representative Cox and I think Representative King are laboring under here is that the first of these qualifications, lines 47 through 53, refer to the appointee. 55 refers to qualifications of the supervisor or the public officer who is prohibited from hiring the appointee. So I think if we want to accomplish the objective that you two are working on, we can change the word supervisory, but we would need to change on line 55 the words public officer to appointee so that it made sense. Because the public officer isn't going to provide the functions for the appointee, is going to provide the supervisory functions for the appointee. So in order to make this consistent, we would have to change public officer on line 55 to appointee so that we're talking about the appointee being the best qualified to perform the functions of the appointee.
Thank you, Representative Green. Comment from the chairman, Representative Christensen. There you go.
I'd like to make a motion if I might. Okay, we good. Substitute motion then.
Do we have only one substitute at this? Do we have a substitute at this point? Did you, Representative King? Did you make a motion?
I reserve the right to make the motion, but I have not made the motion. So I think, as a matter of point of order, it's appropriate for a member of the committee to make a substitute motion if they want to. But we've got the motion before us.
So we have one motion before us. You did not substitute it.
I did not.
But Representative Christensen looks like proposes to substitute it.
If I might, others might have the same inclination, but I'd like to respectfully move that we hold it. And the reason why is that when we folded over to today, we thought that we had it ready. We didn't anticipate the substitute, which are always free to do that. But from a time management standpoint, with just the agenda that we've been trying to coordinate, and so I think that there's so much goodwill in terms of trying to help with the drafting. If the sponsor would be so inclined, I think that some of what we're trying to do here during the committee could be worked out. And that was the purpose of, we anticipated that maybe we had done that last time coming forward to today.
We have a substitute motion on the floor to hold the bill. Do we have any discussion going back to the sponsor, Representative Cutler? Do you have a position?
I would agree with that. I'd like to get with some members of the committee to work this out.
Thank you.
Very good. Any further comment from the committee on this substitute motion to hold the bill? It looks like Representative Stratton, is that your light?
Thank you. I'd like to speak in favor of holding the bill and the motion.
That's in order. Go ahead.
The intent, as we looked at it last time, I think has been addressed, but I think we're grappling with the other aspect of what we want to address. So with that in mind, I support the motion to hold the bill and would be grateful to have that chance to work with the sponsor.
Very good, thank you. I think the next light was Representative Cox, speaking to the substitute motion to hold.
I will withdraw my underlying motion.
Very good, thank you. That simplifies our lives. And still have a comment from Representative Hall.
Yeah, I just want to continue to encourage the sponsor to keep working on this bill. I think the vibe of the committee is that we like this idea. I think it needs to be, it's a good idea, it's a good bill, and if we can just continue to work on the wording, I think we can get it out of the committee and onto the floor.
Thank you.
Back to the movement. Representative Christensen.
No, I thank you. And
Summation.
as you came forward initially, you brought to our attention how many grandparents are raising families and the expanded role of that. And that was the scope of the bill, and we're trying to help you with some of the other points that you've identified. So thank you.
Thank you very much. Before us then is the substitute motion. First one withdrawn, so it's a motion to hold the bill. All in favor say aye.
Aye.
Any opposed? We have a unanimous vote to hold the bill. Thank you very much.
Thank you.
Next on the agenda is a bill from Representative Christensen, Chair Christensen, House Bill number 170.
You're doing a good job.
I appreciate your help. It's nice to have you close. Representative Christensen, the
Thank
floor is
you.
yours.
Thank you. Representatives, I hope this will be quick and simple. I believe that it is. You might recall that it used to be, in recent memory, kind of a common practice that we would sometimes put a sunset review on something that was leading out to kind of break new ground, and then when it was found to have proven to be very beneficial, we would then lift that. Sometimes that would go in a combined repealer bill, but current practice is to do that one bill at a time. I'd like to bring to your attention something that I feel is one of the most productive things I think I've been fortunate to be associated with. But I noticed that I believe one of our greatest assets as the legislative branch is our legislative auditors. What they do is amazing, and they do it so effectively and so efficiently, but they literally pay for themselves 10 times over. The savings that they find in the most positive ways. And so we have a legislative management committee that receives various requests, and ultimately the legislative auditor does about 23 audits a year, and they can cover anything and everything. But one of the things that tends to get easily overlooked, and you're seeing it now in your individual appropriations subcommittee, we're trying to find savings, and many times those savings can go towards public education, for example, or other areas, but especially in education, where we're trying to pull from the various areas. So with the audits that we've done, we passed this bill a couple years ago, back in 2011, and it said that of all the audits you're going to do, of those 23 audits, at least one or two of those should be of the core base budget operations, the recurring ones from year to year. And I was able to bring to the body the attention that if it wasn't for that, it would take 20 years before any of the core operations of government would ever experience an audit that would help us. What we're trying to do is incentivize everyone to be team players in good times and bad times, generate savings from year to year, not have a use it or lose it mentality. And then if you come forward, let's say in 4 or 5 years, and you say we need extra money, you can say, well, you came in under budget the last several years. You helped us here, here, and here. You build credibility, and we're being as prudent as we possibly can be. So what this does is it lifts the repealer date because we've found those good results. And then it also, whereas before it said that at least 2 of the 23 audits would be of the core recurring operations, as a practical matter, because these are a little bit more in depth than some of the others, and with the session, it might take 15 months to do one. So technically, 12 months was just a tad rigid. So we're pulling back. Instead of saying at least 2, it'd be at least 1, but then we would lift the repeal date and make that an ongoing feature. Let me just, by way of report, share with you what their office shared with us. We first did a Department of Corrections audit, and we found that about 25% of the fugitive population was inappropriately receiving public assistance benefits while they're incarcerated in the prisons. We found that we also found that there was greater accountability over public assistance funds. We found that the recidivism rate, and you're going to see a major initiative come forward now with CCJJ, where we find that 62% of our inmates are nonviolent offenders, and that there's a kind of an excessive reliance on felonies. That's another thing that's brought to light. We're going to see some very positive adjustments. We found that the Draper Prison can save $1 million annually through better food management. We found $560,000 in potential annual savings through better medical care, contracting, oversight, etc. We also went to the Department of Human Services, and we found significant savings there, resulting in $3 to $6 million in annual savings. We found that the Utah State Hospital did not have adequate controls regarding off-site medical visits. We found in the Health and Human Services area, that's what led to the $47 million in federal money that was incentivizing permanent termination of parental rights. That's been a huge breakthrough for us as well. We now have a current one that's about to come forward on an audit, a voluntary audit, that in cooperation with the Attorney General's office. So as we transition through, we'll have the benefit of a historical overview of that. And we have one that's now about to begin with regard to public education. So with those good measures, I would ask for your support to give them a little flexibility, go from 2 to 1. That'll give them more 15 months instead of 12 months to do it. And then if someone wasn't comfortable with the repealer, you could extend the date, but I think it qualifies at this point individually to make this an ongoing prudent measure where we'll always have the assurance that at least one of our audits each year will go to those core operations, and we'll be building up the library, the history, so that there'll be future transparency and accountability going forward from year to year. Thank you.
Thank you, Chairman Christensen. Does that conclude your presentation then?
It does.
Let's go to the committee for clarifying questions about the bill. Anything from the committee? Representative King.
Hello?
I'll try again. There it
Thank you,
is.
Mr. Chair. I agree that our audit process from our legislative auditors is very important, and we've gotten some great information from them. They work hard and do good quality work. It appears that we're reducing the audits that they would perform on these appropriations rather than either maintaining them or increasing them. Am I missing something?
Because it says at least, do you see the words right in
Yeah.
front of it? So right now it says at least 2 per year. By saying they wanted to make it 1 or more, because the at least language is there. If we went to 1, then we would give them that 3-month window flexibility. That's the only reason we were doing that. I would love to have at least 2. I trust them to do 2 to the extent that they can, but it just gives them a little bit more calendar flexibility.
I don't understand that. I mean,
If you'd like to leave it the way it is, I'm fine with that.
well,
but
no, I
that's-
just want to understand what benefit we get from changing it from at least 2 entities to at least 1 entity. You talked about a calendar flexibility, but is there another change that relates to the calendar at all?
No, that's it. Because it says each year perform an audit of at least 2 appropriations in addition to the others. So just 2 of the 23, this would make it 1 of the 23. But because it's at least, I don't think I'm not concerned that they'll pull back and do 1 less. I just thought in being sensitive, because this one is more in-depth than the others, and so it requires a little more work. It isn't the same because it's a performance history audit and an in-depth audit budget. It's almost like 2 in 1. And so it's because it's 2 in 1 and the way it's described, when you look at the A, B, C, and all those elements, that's what makes it a little more thorough than the others. So if you're going to do 1 of those rather than 2 of those, but it just gave them the flexibility. So I'm just being sensitive to, they weren't complaining at all. They were just telling me that because of the thoroughness of it, that they thought that was a good way to go.
I just can't see how this has any potential to do anything but reduce the number of audits we're likely to see of the appropriations process or agencies that we're dealing with.
If you'd like to leave it at 2, and if that's the will of the committee, I mean, I'd like to have more, but I also trust them because they do such a thorough job that I'm okay with it. I think what you'll get is you'll get it, but you'll get it within maybe 15 months, 18 months instead of a literal 1 year, 12 months. It just gives them a little bit more flexibility to do it because it says at least. And in talking with them, I feel like that was not a step backwards.
Thank you. Is that all, Representative King?
Yes.
Any other clarifying questions from the committee? I see none. In the next phase, we go to the public. Is there any comment from the public on this bill? No comments from the public. Back then to the committee for action on the bill. Representative Cox.
Thank you, Mr. Chair. I would like to move HB 170 out favorably.
The motion is to approve House Bill 170 with a favorable recommendation. Any comment from the committee on, or Representative Cox, do you want to talk about your motion first, and then we'll go to the committee?
Well, one, I agree that the legislative audits are critical. We have found a number of things using them in the past. Obviously, you do not want that process to sunset, and I do not mind giving some flexibility if they spend a little bit more time on one. The goal is that we keep on asking for them. The management committee decides what items they're going to go for, and we're adding some flexibility if we want them to spend a little bit more time on one item and less on a couple of others. We have that flexibility, and so I'm okay with the bill.
All right, thank you. Any other comment on the motion to approve the bill favorably, Representative King?
Thank you, Mr. Chair. I just, if the legislative audits are a positive thing, and I think they are, it's hard for me to see how this change doesn't decrease their effectiveness, because it increases the likelihood that we won't have as many of them, from what I can see. So I'm not going to support the motion, but I'll talk with people from the legislative audit folks and ask them what I'm missing here.
Thank you very much. Any other comments from the committee on the pending motion to approve the bill? Seeing none, we'll go back to the sponsor of the bill for summation.
Thank you. Just ask for your support, and again, affirm what an amazing asset the Legislative Auditor's Office is, and how grateful I am for the work that they're doing. And I believe that this right here has tremendous potential, and I think it will grow and become even more effective as time goes on. Thank you.
Thank you. And Representative Cox, do you have any final words on your motion?
I'll waive.
Summation is waived on the motion, so the motion before us is to approve House Bill 170 with a favorable recommendation. All in favor say aye.
Aye.
Any opposed? No. We have a negative from Representative King. We rule that it passes, and with one negative vote.
It's the hard part to get in the habit of announcing them.
Okay. The next bill on the agenda is House Bill 35, Parent Time Schedule Amendments by Representative Snow. Are you prepared, Representative? Let's see if I can find your light. There we go.
It is the next matter on the agenda, Mr. Vice Chair, but I've asked the Chair if we could hold that over until the Judiciary meeting scheduled tomorrow at 4 p.m., and I understand that that's being placed on the agenda to be heard at that time.
Do we need a motion to drop that? We can do it? All right, we'll strike that item from the agenda. Thank you, Representative.
Thank you.
The chair has the power to shuffle the agenda, or
Right in
skip
place.
over things right in place.
Or drop them from
Or
the
drop
agenda.
them. Yep.
Okay. Next item then on the agenda, House Bill 74, Representative Romero. I don't see her here.
Is our intern here, maybe?
Representative King.
Move that we move on to the next item on the agenda and see if we can get Representative Romero here.
Do we need to vote on that? Or?
Yes, you should, if it's a motion.
Motion before us to move to the next item on the agenda. Any discussion of that motion? Representative Green.
My only concern is I don't see the sponsor for the next item on the agenda either.
That's a valid point. We may all escape early. Why don't we saunter for 5 minutes? We can do that without a motion, can't we?
Senate. You could also take a motion to recess. That was your intent.
So stay close. Hopefully we have interns trying to locate the two sponsors of the next two bills. Okay.
Apologize. I apologize for my tardiness, but I was in another committee.
I serve on the Education Committee. That's the only one where tardy is relevant, so you're doing good.
Thank you, Representative.
Need a motion to be sauntering. Do we have a quorum? We do. All right, so we'll bring our sauntering to an end. And the next item on our agenda is House Bill 74. We have the sponsor here, Representative Romero. You have the floor. Go ahead, please.
Can I pass these information sheets out?
We may be able to have someone help you with that.
Thank you. Can I start?
You're free to go ahead, yes.
Okay, HB 74. What is the purpose of HB 74? There are 12 separate specific scenarios for lack of consent in sexual activity in Utah. They are outlined in subsection of UCA 765406. The majority of sexual assaults prosecuted are based upon subsection 1. However, there are other subsections because other subsections become important in some cases, but two of those subsections are confusing and virtually impossible to prove by the state. So HB 74 recommends that HB 74 proposes to delete the bracketed phrase in subsection 5, the victim has not consented. HB 74 proposes to add language outlined in red, so I apologize, I want to motion, do I motion to pass an amendment prior to presenting on this bill? I have an amendment to the bill. I apologize.
Distribute the amendment, speak to it.
We have a conflict in our rules, but I think we'll go ahead and make amendments as you need.
Okay.
So,
Is it a verbal or a written?
It's a written amendment.
Have her distribute it.
If it could be distributed, that would be nice. It should be on your laptop. I didn't bring a copy of that.
call upstairs and see if we can get some.
Is the amendment online?
Yes, it is.
Can I see the draft? To the bill, but we do not have copies. It looks like Susan drafted it. It's House Bill 74.
Amendments ready.
If they're coming.
I apologize, I just assumed that it would be here since this amendment was proposed a week ago.
Original bill, House Bill 74. We're looking for any amendments drafted by Susan. So Susan's likely to be the sponsor or the drafter of the amendments.
We're trying to locate the hard copies of the amendment.
Why
Just
don't you let her carry on with her presentation, and then we can distribute the minutes when they arrive.
do you want to go forward with your presentation, Representative?
So HB 74 proposes to add language outlined in red as amended. In subsection 6, the actor knows that as a result of mental disease or defect, or for any other reason, the victim is at the time of the act incapable of either appraising the nature of the act or resisting it.
Representative, are you explaining your proposed amendment?
Yes.
Would you give us an idea just verbally of what it is and which line it's on?
So the proposed amendment would be line 19 and so on page 1, line 18 through 19, and on page 2, line 54.
And on line 54, what happens?
So on line 19, line 19 would actually say, resisting the offense, the cause of the incapacity includes any other reason in addition to the current reason of mental disease or defect. And on page 2, line 54, the actor knows that as a result of mental disease or defect or for any other reason, the victim is at the, I'd have to pull up the bill as well. At the time. At the time of the act, incapable of either appraising the nature of the act or of resisting it. So what we've done there is...
So let me just repeat that to clarify then. On line 54, which is part of the bill,
Yes.
it would say, and carrying on from up above, it's without the consent of the victim under the following circumstances, sub 5.
No, actually
sub
sub 6.
The actor knows that as a result of mental disease
Or defect or for any
That
other
being
reason.
reinstated?
Yes, reinstate.
So you're reinstating what is lined out?
Exactly.
Okay.
And she's adding.
And we've added or for any other reason.
So the actor knows that as a result of mental disease or defect, or for any other reason,
The victim
the victim is at the time of the act incapable, and so forth.
Correct.
All right. Go ahead.
Okay. And why is this change needed? Proposals are being made by HB 74 to delete the confusing language and make some additions for the standard, to make the standard more clear. These changes are improvements for both the prosecution and the defense. The changes will give defendants better notice and opportunity to prepare their defense and delete things that are impossible for prosecutors to prove and are confusing to judges and juries. Another reason why this is needed is to protect those who are vulnerable from being sexually assaulted by clarifying conditions under which a sexual act is committed without consent of the victim. That concludes my introduction.
Let's go to the committee then for clarifying questions about the bill. Representative King.
Thank you, Mr. Chair. Representative Romero, I assume that in the amendment, we still retain this strikeout language on line 52, subparagraph 5.
Correct.
Thank you.
Thank you. Representative Green?
Thank you. I appreciate the sponsor bringing this bill forward and the way she has gone about it, coming to all of us as early as last week and explaining what her intentions are. I did share a concern with her at the time, and I want to make sure I raise it in committee, make sure that everyone understands this, or if I don't understand it correctly, maybe I could be enlightened on this. But it seems to me that the change on line 52, and this is not a pleasant thing to even envision, but that the act of having sex with an unconscious person is now statutory rape. It is essentially a strict liability standard. If you have sex with an unconscious person, you are committing rape. Because we've taken any reference to consent out of that. Prior consent, implied consent. Consent is no longer a factor. And if that's a policy decision we want to make, then we can do that. But I want to make sure that I'm understanding this correctly, because it looks to me now like sex with an unconscious person is by definition rape. There's no defense to it.
Could I defer that question to Donna Kelly?
I think we'd rather wait and hear from her during the public comment. Let's hear just clarifying questions at this point from the committee. You're free to respond, and then we can call in your well, I don't know.
Point of order, wouldn't that be I'm asking a clarifying question. If the sponsor wants to defer to
an expert,
I don't have a problem with that. I'd like to hear the response.
All right, let's go ahead then. Could you identify yourself, please? I'll turn on your microphone here. Okay.
My name's Donna Kelly. I'm from the Utah Prosecution Council.
Very good. Go ahead.
Thank you very much for allowing me to be here and be heard. The subsection 5 of the Utah's consent statute is the only place where it requires a double burden, which is very nonsensical, because how can a victim express lack of consent if they're unconscious? How can a victim express lack of consent to an issue if they're unaware that it's happening? It's the only subsection of this statute that requires a prosecutor to prove that the victim didn't consent and these other circumstances exist, which are impossible to prove if the victim is unconscious. You cannot give consent to a sexual activity if you're unconscious.
All right.
And so what happened by House Bill 74 is it clarifies what the legislative intent is. The legislative intent is to protect extremely vulnerable people from sexual attack. And so removing that consent language from that one subsection, just like it is in all the other 11 subsections, clarifies that our legislative intent is to protect extremely vulnerable people from assault.
Representative Green, go ahead.
So are you saying then that there is a overriding consent requirement that still applies, even though we remove that language in subsection 5?
My understanding of this statute is this defines circumstances in which there is no consent. That as a matter of law, as a policy matter, these are circumstances in which consent is not given.
Okay, so my interpretation then is correct that sex with an unconscious person is rape.
Yes.
And that's the concern that I have. I don't know that we want to go there as a policy. I certainly understand with these vulnerable victims. I'm just wondering if there's a better way or another way to approach that so that, for instance, I hope this wouldn't happen, but this opens the door to it, an individual has sex with their wife while she is unconscious, or he, the other way around, if that's possible, I don't know. But a prosecutor could then charge that spouse with rape.
If
Theoretically, I'm not interested in, you know, whether the wife would have to come forward and make that allegation. I'm just saying, under that scenario, that would constitute rape.
this statute prescribes that people cannot give consent when they are unconscious or unaware that something is happening. The consent cannot be given.
I understand that. And that makes sense in a first date scenario, but to me, not where people have a history of years of sexual activity. It takes away the defense of implied consent or prior consent, does it not?
Consent is a decision that has to be made at the time of the act. It cannot be, for example, if someone gave consent and said, I will have sex with you on Friday night, but then that person winds up in a car accident unconscious in the hospital on Friday, that other person can't come to the hospital and have sexual intercourse with that person because they previously gave consent. It's a decision that has to be made. The circumstance that you're talking about is covered by subsection 1, which is that the husband and wife have, the wife has consented. What you're saying is the wife has consented to that kind of activity. So it's covered by subsection 1 in that particular circumstance.
The subsection that says the victim expresses lack of consent through words or conduct?
Yes, because if the wife expresses consent to that kind of activity while she's unconscious, then it would not be a crime.
Well, she can't express that consent while unconscious.
Right, and I'm saying that a prosecutor would not file that case because she has given affirmative consent in that circumstance.
I don't see that as the same circumstance. What I'm trying to determine, is there any scenario under which a person could have sex with an unconscious person that would not constitute rape under this change?
If they factually had given consent to that activity, a prosecutor would not file that case.
So in other words, they would have to say, you have an open door policy. Anytime I'm unconscious, you can have sex with me. That would be the only circumstance?
It would be up to a judge and jury to decide.
Right.
And as in every subsection of this statute, a judge and jury would make a decision whether or not that is consent.
I just think that is a sweeping change, and it may result in a lot of unintended consequences. I certainly understand what the sponsor's trying to do. I'm supportive of that, but I think we're potentially opening the door.
Thank you, Representative. We'll go to Representative King. Any clarifying question at this point is what we're looking for, rather than ultimate outcome.
Thank you, Mr. Chair. I want to be sensitive to this. This was a comment, an inadvertent comment made by the previous representative when he referred to, he made a reference in his comment to if this bill on line 52, the language on line 52 passes, a person would be guilty of statutory rape. Statutory rape is defined as rape with a minor, as opposed to this bill, which deals with, unconsented sexual relations with any individual, regardless of age. I want to be careful about the terms we use. That's all.
Thank you very much. And Representative Stratton.
Thank you, Mr. Chair, and thank you for your efforts to the sponsor. Are you aware of any circumstance when consent is assumed?
I'll defer that to Ms. Kelly.
Again, it is not a question of assumed, it's a question of what the judge and jury find. The judge and jury have to decide, judge or jury has to decide whether there was consent or no consent given in this particular case. And this statute, we had a decision last week by the Utah Supreme Court that interpreted this statute. These are not the only circumstances under which lack of consent can be found. But this is These specific circumstances listed in the statute are policy decisions by the state of Utah to identify where a consent cannot be given.
Thank you. As a follow-up question then,
Yes, go ahead.
is there a circumstance that the judge and jury would not have to determine consent?
No, that's would have to be determined in every case. In other words, if the theory of this crime is lack of consent, then the judge and the jury have to decide it on a case-by-case basis.
Okay, so I'll ask one more question, and then what I hear you saying then is if a husband and wife both are conscious they engage in the intimate relationship, and later one claims, I didn't give my consent for that, there would still be a need to have a finding of fact on whether there was consent or not. That wouldn't be assumed because you're married and there's no other mitigating that there was consent.
Absolutely.
Okay.
That is always the case, that the judge and the jury make the decision if there is consent given.
Thank you, Mr. Vice Chair.
Thank you, Representative. Representative Snow.
Thank you, Mr. Vice Chair. And thank you for your presentation, both of you. This is a question, Representative, for your guests, and I apologize I didn't get the name, from Prosecution Counsel. The issue of consent or non-consent is in a rape trial is whether before a judge or a jury. It is an essential element of the offense. Is that correct?
Yes.
And the state, who has the burden to prove non-consent?
100% burden on the state.
The state has to prove that. And then their burden of proof is beyond a reasonable doubt. And in our system of justice, that is the highest burden that is carried by a party in litigation in our state. Isn't that correct?
Yes. And rightfully so.
And so in the scenarios that have been raised, say between a husband and wife situation, in that situation, just because they're husband and wife doesn't change the burden of proof, correct?
No, it does not.
And in that case, if there were an allegation of an impropriety, first of all, it takes a victim who is willing to bring that claim. Is that correct?
Yes.
It's not the state that goes out and investigates and those on their own.
No, we don't. No.
And upon that investigation, if a claim is brought in court, the requirement would be that the state in that situation would have to prove beyond a reasonable doubt that consent was not given by that spouse. Is that correct?
Exactly.
Thank you very much.
Thank you, Representative. Any other clarifying? Oh, we have one more. Representative Cutler.
Just a quick question. On line 6, you initially took out the as a result of mental disease or defect, and then you put it back in. Just curious why.
It was a discussion amongst a variety of providers, and we felt like we wanted to protect people who may be in a relationship that are both mentally ill or have a defect. So that's why we put for any other reason.
Is that all, Representative Cutler? Very good. Representative Chairman Christensen, go ahead.
If I might, just following up with some of the things that have already been said, but when you reinstated the language that you originally in the bill proposed to delete, draws attention to the sufficiency of the bill, of the statute in its current form, as you've put that language back in. But you've replaced it now with two things that I'm struggling with you can speak to. But when you put or for any other reason, so the open-ended nature of for any other reason, that is so open and vague. And then I really feel that the opening sentence that you've pointed out appropriately, line 39, in current code, the victim expresses lack of consent through words or conduct. that is fact specific, and so on a case by case, there's no potential for unintended consequences. You're either one or the other, your words or conduct. And so with the heavy burden of proof, rightfully so, on every case you can go in one by one by one. You can make those same arguments. So what we're being asked to do, invited to do, is to be more specific. And that's, except that the problem is that you can have the unintended consequence of being so vague and so broad that we've gone backwards, not forward. And so it's very sensitive. It's a topic that's uncomfortable to even have, but it's one that you don't want to have the wrong outcomes. But I'm looking at your new language, and it seems to me that you're creating a new conflict between subparagraph 1 and your proposed replacement at 6, is it, that you're trying to create? One is sufficient. It ensures fairness. You already have everything you're advocating for in 1. On a fact-by-fact, case-by-case basis, you can go to court and you can prove it. And so that one covers you. And then I'm worried about this new language, or for any other reason. So taking what Representative Green pointed out, the potential unintended consequences, the double newness of the openness of, or any other reason, coupled with just the blanket per se unconsciousness. We hear so much talk about consensual relationships, and if someone were to argue, and they're free to argue it in their defense, they're free to go in and argue with words or conduct. One will say, our relationship allowed, and the other one will say, no, it didn't. I've been really sensitive to the cases. There have been some historical cases where people were in very permissive relationships, but it doesn't mean doesn't mean that someone consented to the most extreme manifestation of physical involuntary affection because they were participating and cooperating in some of the lesser forms leading up to it. So I'm very sensitive to what you're saying, and I'm nodding as you're nodding. But my specific question is, do you really feel that subparagraph 1 doesn't strike the appropriate balance currently on a case-by-case basis in jury trials? And do you really feel that the blanket exception of, or any other reason, is something that we could prudently accept?
Again, I will defer the question to Ms. Kelly.
And the answer is yes. I really feel that the changes to subsection 6 are necessary. And subsection 1 does not cover the circumstances of subsection 6 because subsection 6 deals with situations where the victim is at the time incapable of appraising the nature of the act. So they cannot, under subsection 1, express lack of consent to something that they do not understand is happening.
Why would not conduct include being asleep or being unconscious?
Those are covered in other subsections. This subsection is meant to deal with a situation, for example, if you had a handicapped adult that is not able to understand what's happening and therefore cannot give consent to it. But there are other circumstances as well besides a mental disease or defect. People might have a head injury. People might have taken medication. I screened cases in Utah County where a woman had had surgery and had been given medication and was not able to understand what was happening because of the effect of the medication upon her. So the language of mental disease or defect was left in to clarify that legislative intent is there to protect these vulnerable people, but there might be other circumstances where a victim is unable to appreciate what's happening. And the specificity that you're talking about, which is so important, I appreciate that comment, remains in the language that the prosecution must prove that the defendant knew beyond a reasonable doubt that the other person was unable to appreciate what was happening and give consent to it. So the state must still prove that part of it, but the exact mechanism of why that victim was unable to appreciate can include more than mental disease or defect. Our safety, our protection for our individual freedoms, and our right to defend ourselves is still present because the state must prove that the defendant knew beyond a reasonable doubt that the other person was unable to appreciate what was happening.
And if I might, I'm just, with all due respect, I think it's just the opposite. Sometimes it's a statutory temptation we deal with every day. Once you start creating a list, and it's like, are you on the list or you're not on the list? So many times when you're trying to cover more situations, a broader definition, rather than trying to make each person define their individual category. And so that opening one about through words or conduct, that is appropriately broad enough to cover each and every case on a case-by-case basis. And it doesn't tie the hands of the jury, it doesn't tie the hands of the judge. It gives them the maximum opportunity to look at the individual case, and both sides can make their arguments either way. And then with the new amendment, to have this or any other reason, to just have that also in there. So I'm struggling with, I understand the situation, but I'm having a hard time seeing why the existing language not only doesn't cover it, but doesn't cover it better than the proposed change. That's what I'm struggling with. So I just appreciate the clarifications that you've given.
Thank you, Representative. To Representative Cox, it looks like you have a comment or a question.
Thank you, Mr.
We're doing
Chair.
clarifying questions at this point.
Yes. Your addition on line 54, or for any other reason, if I understand it, and I just want to make sure I'm understanding the change, all of that refers to the keywords on line 55, incapable either of appraising the nature of the act or resisting it. And so, as I understand, not in context or for any other reason sounds pretty vague, pretty open-ended without any limitations. But all of that is applying just to the words on the next line, which is incapable of either appraising the nature of the act or resisting it. I just want to make sure I'm clear, because as I read it in context, I don't see something that isn't defined. And I just want to make sure I'm reading it right.
Right. You're exactly right. It does apply to that language only, and the state must prove beyond a reasonable doubt that the defendant knew that.
The other thing I wanted to just comment on is, since I'm not an attorney, I'm an architect, but the words that you have that you're changing on items number 5 and 6 mean something to me. And if I were on a jury, they would matter. Thank you.
Thank you for that comment.
Thank you, Representative. I see no other comments from the committee. We'll go to the public and see if there's any comment on House Bill 74.
Can I have my two other witnesses before, or do you want?
Okay, sure. I thought, I'm sorry, I should have gone to you to complete your presentation. Go ahead.
Kim, can you come up?
Hello, I'm Kim Fisher with ABC4 Utah. I was asked to come here today to speak about a sexual assault that happened to me when I was in college. And it correlates pretty well with the changes in these laws. So let me take you back to my freshman year in college. My boyfriend and I had just broken up. I was devastated. I reached out to a couple of friends. They were a couple. I worked with the girl. He was in the fraternity with the guy. I called them, upset. They said, come over. We're having some friends over. Come hang out. Get out of the house. Stop thinking about it. Of course, I was an 18-year-old girl, so I didn't stop thinking about it. I went and I just cried and kept talking about it. And, the night went on, and they ended up saying, why don't you just stay the night over here so you don't have to go home, be alone, sleep on the sofa. I appreciated that because I didn't want to be alone. I didn't want to keep thinking about this all by myself. So I fell asleep on the sofa. Sometime in the night, I woke up with a man on top of me. It was my boyfriend's fraternity brother. My friend's boyfriend was on top of me. He had his hand up my shirt and was kissing on me. In that moment, I don't know why, the only thing that my brain told me to do was not scream, was not push him off, was to act as if I was asleep and start saying my boyfriend's name. Thankfully, it worked to an extent, and he did not rape me, but he did take advantage of my body. After that, I I didn't tell anyone. I didn't want the questions. I didn't want to be asked, well, what were you wearing? Well, why did you stay the night? Well, did you do anything that would have led him to believe that that you wanted him to make this move on you? So I never said anything. And unless you think an 18-year-old girl crying over her boyfriend is some sort of form of consent, I didn't give consent. I never talked about this until about 3 weeks ago when I was doing a story with Holly Mullen at the Rape Recovery Center, and I told her because I trusted she wouldn't judge me. Last week, she asked me to come and tell you guys my story because it fits in with this. If I were your daughter, your niece, a friend, how would you want this law written? Would you want it written in a way that left it to a he said, she said that could end up letting him walk because I couldn't prove consent? Or would you want it more defined? Would you want me protected? Thank you.
Thank you very much for taking your time to be with us.
My name is Derek Deitch. I want to thank all of you for taking the time to hear my statement today. I am a current student at the University of Utah and a member of the fraternity Beta Theta Pi on campus. I have had the opportunity to hold a position within my fraternity, which has given me the privilege to work with the Rape Recovery Center and the Center for Student Wellness on campus, as well as some other organizations, to kind of lead an effort to prevent sexual assault on campus. One of the things we've been doing is hosting sexual assault prevention forums. And through that role, I have become aware of a very large issue that I didn't know about before. And that is sexual assault, specifically on college campuses, but also in the community as a whole. One thing that I've realized is that while I may not specifically be involved with any sexual assault, I am involved in preventing it. And it's something that I think this bill is very important in clarifying. As a male, I think it is very important to hold other males accountable for their actions and their decisions that they make. And I think it's also very important to preserve the right of all individuals to decide for themselves when and with whom they have sexual interactions with. This bill, I think, helps to clarify that, and it really does help anyone involved to make that decision for themselves. And I don't think that there is any circumstance or situation where somebody should have sexual relations without giving consent to do so. Regardless of their relationship with somebody that does not provide implied consent, they have to give consent on every single occurrence. And I'm just here today to support this bill so that I can support the rights of every individual to make that decision for themselves. Thank you.
Thank you very much for your testimony. Representative Romero, anything else in your presentation?
No.
Let's go to the public for comment then. Is there anyone in the public who would like to comment on this bill? I see none. Let's come back to the committee for committee action. And one of the first items is, of course, a motion or an amendment here that has been discussed but not moved. Representative King.
I'd like to move Amendment 2, dated February 3rd, 2015 at 3:12 p.m. to HB 74.
Thank you very much. The motion is to amend House Bill 74. It's amendment number 2. All of you should have hard copies now of the proposed amendment. Does anyone not have it? Representative King, would you like to discuss your motion to amend?
Well, I think we've discussed it. I think the language of the amendment has been discussed by the bill sponsor, and I don't really have anything to add.
Very good. Let's go to the committee for comments on the motion to amend. Any comments? I see none. Representative King, back to you for summation on your motion.
No, Webb.
Summation is waived. Let's vote on the motion to amend. All in favor of the motion to amend House Bill 74 with the amendment proposed, please say aye. Anyone opposed? So it's a unanimous vote. The bill is amended. And now we'll discuss or come to the committee for action on the bill. And I see Representative Snow.
Thank you, Mr. Chair, Vice Chair. I would like to make a motion that we move House Bill 74 as amended out with a favorable recommendation, and I'd like to speak to that motion briefly, if I may.
Very good. The motion is to move out House Bill 74 as amended favorably. Representative Snow, go ahead.
Thank you. These are, this is a sensitive issue, and I think most of the members of the committee are aware of that, and I appreciate the sponsor bringing this issue forward and addressing the statute that probably is deficient with respect to, in this case, consent by someone who is incapacitated or unable, for whatever reason, to give consent. It is of a concern with the scenarios that have been raised, but the reason that I asked the questions that I did about the burden of proof is because in a criminal case, one of the great protections afforded to a defendant charged with any crime, including a serious crime like this, is the state has a fairly high burden of proof. Not fairly, a high burden of proof. And every element of a crime must be proved beyond a reasonable doubt to the satisfaction of either the judge or a jury sitting on the case. I don't think, having been a prosecutor, I can think of scenarios on almost with respect to every crime that is on our books that you can think of that may be unusual in its fact or circumstance. But in terms of whether or not it is a perfect recitation of what ought to be a crime on the books or not. But in almost all cases, a defendant is protected with that burden of proof. And I'm confident that in this case, the statute needed to be clarified, needed to be fixed, and that the language is proper. And in terms of it having any overreaching effect that may leave someone liable in an unintentional way, I believe can be addressed properly in the court. So thank you, and thank you, Mr. Vice Chair, for allowing me to make that statement.
Thank you, Representative Snow. Further discussion of the motion to pass the bill out favorably as amended. Representative Wheatley. Very good. We'll cancel that light and go to Representative Green.
Thank you again, Mr. Vice Chair. This is a very difficult subject. It's not comfortable to sit here and talk about it. It's even, I must imagine, even more uncomfortable for those to talk about it who have experienced these things, and I appreciate those who've come forward to do that today. Here's where I struggle, and I'm ultimately going to support the bill, so I support the motion, but I do want to call again the attention of the committee to this possibility, because I think it speaks to Representative Snow's reliance on the courts and the judicial process and having to approve every element of the case beyond a reasonable doubt. This statute, as amended, will take consent out of that burden of proof. That will not be a factor to the case where the actor knows somebody is unconscious. Let me just read quickly the pertinent parts of this statute, beginning on line 32. An act of sexual intercourse, jump down to line 37, the last 5 words there, is without consent, carrying on to the next line, of the victim under any of the following circumstances. Jump down to 52, the actor knows the victim is unconscious. That's the only element that will have to be proven, that the actor knew that the victim was unconscious. I am 110% supportive of trying to find solutions to those cracks that people, predators have slipped through. Because I understand there's some real cases that we're dealing with, and that's what has prompted this change. But this takes consent out of the elements of proof. The only, in that scenario I've given, and I'm not trying at all to justify sexual activity with an unconscious person. It's abhorrent to me. But do we as a body, a legislative body, want to make that rape in every instance dependent only upon the actor's knowledge that the individual is unconscious? That's the question. That's what I struggle with. But as I said, ultimately, I am supportive of the motion.
Thank you, Representative Green. Further discussion of the motion, Representative Chairman Christensen.
I wanted to thank Representative Green because he was spot on with the technical legal points, more than technical, but I really am sensitive to the college campus. I've seen that many years later. I've had people tell me of the most heart-wrenching things that happened that never thought could have happened. And so that I'm very, very sensitive to. His detailed analysis is exactly right, and I would just ask the bill sponsor to seriously contemplate. That's what the process does, always trying to get the wording right until something ultimately is adopted. But if you look at 52, striking the words "the victim has not consented," that in the balance of innocent till proven guilty in any kind of a situation, not trying for a moment to justify this delicate and sensitive area that nobody's comfortable with, but it is in the context of all criminal charges. And so that's what jumps out at you the most when everything else that you've balanced out. But the one thing that's the most striking is taking those words out. The victim has not consented, has per se absolutely eliminated a defense that someone might have tried to raise. We're not trying to sanction it one way or the other. And it's not a test of our sensitivities or our compassion. We're just trying to make sure we can watch over that process. So that's the delicacy of all of this, and we're trying to understand from the questions, if it's not broke, don't fix it. What is it about the current law that has somehow left it to be vulnerable? And I really appreciated Representative Snow. I think he's right on also in saying that the system has fairness and individual case by case. The scales of justice are there, but this could potentially tip those scales of justice a little bit one way or the other, and that's what's being considered today. But those are the words I think that when all is said and done, that's probably the most striking change of the whole thing, is that one deletion on 52. If it diminishes the scales of justice, whereby both sides can state their positions.
Thank you, Mr. Chairman. Further discussion of the motion, Representative Stratton.
Thank you, Mr. Vice Chair. I would first like to thank those that have joined the sponsor and witness today for the committee. We are appreciative of your willingness, and thank you for that, and acknowledge that sometimes it's not easy. The second thing that I'd like to comment as to the motion, I spoke earlier about the notion of consent, whether it's assumed or not, and recognizing I wanted that to be part of the record. But I'd also advocate that non-consent is not assumed either, without at least a threshold of the triers of fact coming together to determine that. And at some point, as a legislative body, we need to do the best we can to recognize that one size doesn't fit all, but recognize that there's an opportunity in these circumstances to allow a case by case to be heard with the checks and balances that are there. we can't create legislation that will be perfect, and I apologize to my colleagues with that acknowledgement, but that is a truth, and we've got to do the best we can. And so on this, I speak in favor of the motion with great trust placed then in the triers of fact that represent the people on the jury. And I, again, appreciate the sponsor and those who participated in this very sensitive discussion today. Thank you, Mr. Chair, Vice Chair.
Thank you, Representative. Representative King, you made the motion, right? Is it Representative Snow that's on? Oh, I'm sorry. I thought
Thank you, Mr. Chair. No, Representative Snow made the motion. I just want to support the motion. I want to address a comment that was made earlier that subparagraph 1 on page 39 may be broad enough to cover this conduct. I just don't think that's accurate. The victim expressing lack of consent through words or conduct is something quite different than a victim who, by false pretense or tricks or fraud, basically, is rendered unconscious and unable to give consent one way or the other. So if you have an individual who has a drug slipped into a drink or food that renders them unconscious, it can't fairly be said that they have expressed lack of consent through words or conduct. But it is quite clear, and I think everyone on this committee would agree, that in that sort of a situation, there is not any meaningful degree to which it can be said the victim consented to an individual having sexual relations with them later. So I do think that the language in subparagraphs 5 and 6 is necessary to deal with that, to make more clear that when an individual has sex with a victim that the individual knows is unconscious or is unaware that the act is occurring or is physically unable to resist, and the state can prove that beyond a reasonable doubt, that's rape, period, end of story. And I think we need to make it as clear as crystal that that's true, and that we as a legislative body are intolerant of that behavior, and that we will, to the extent, again, that the prosecution can prove beyond a reasonable doubt that that occurred in that scenario, that's rape. Let's make the statute clear. Let's not dance around it. I think that these comments that have been made about the need for having confidence and trust in our justice system, our criminal justice system, are absolutely accurate. And I do have confidence in it. But I want to make sure that everyone understands, our prosecutors understand, our criminal defense lawyers and our criminal defendants understand that there's no refuge in arguing that the state can't or hasn't proved lack of consent by some ambiguity in the statute. So I appreciate the bill sponsor for bringing this. I think it's a good bill, and I support the motion.
Thank you, Representative King. Let's go back to the sponsor of the bill, Representative Romero. Do you have any closing comments?
Yeah, why this change is needed. Proposals are being made by HB 74 to delete the confusing language and add some language and make the standards more clear. These changes are improvements for both the prosecution and the defense. The changes will give defendants better notice and opportunity to prepare for their defense and delete things that are impossible for prosecutors to prove and are confusing to judges and juries. To protect those who are most vulnerable from being sexually assaulted is clarified in this proposal. I also want to mention that I do have support, and it's listed on here, from the Utah Council of Victims and Crimes, the Utah Domestic Violence Planning Advisory Committee, the Utah Domestic Violence Coalition, Law Enforcement Legislative Committee, and many others. And with the amendments, hopefully the support, because they do support the concept, the Utah Sentencing Commission and the Commission on Criminal and Juvenile Justice. This bill has been vetted by many, many individuals who are experts in this area, and so I ask for your support. Thanks.
Thank you very much, Representative. Let's go back to the the maker of the motion, Representative Snow, for summation. Do you have a summation?
Just briefly, if I might, Mr. Vice Chair, thank you very much again, sponsor, for bringing this bill forward and clarifying the position. And I failed to mention thank you for those who have participated. I know that's not an easy thing, and it takes a lot of courage to express those views, but oftentimes it is those personal views that help us in making our decisions, especially when it comes time to clarify the law in this situation. I think I'm hopeful that this bill will move forward, become law, because it's not only an important tool for protecting people, but I also think that it will become an important tool of educating people. And I think it can be used to educate our young people in school and on campuses, and all people about the limits of what we will tolerate in terms of protecting or allowing vulnerable people to be taken advantage of. That's my summation. Thank you, Mr. Vice Chair.
Thank you, Representative. The motion before us is to pass out House Bill 74 with a favorable recommendation as amended. All in favor of that motion, please say aye. Aye. Any opposed to the motion? The motion passes unanimously. The bill is passed out favorably. Thank you very much. We have a motion to adjourn. All in favor of the motion? Any opposed? The meeting is adjourned.